If you're in real estate, you've probably been in a situation where another party has threatened to do something they're not supposed to do under the contract. So what do you do if you actually follow through and default? What are your rights? Can you sue them? And more importantly, can you recover your legal fees? This video is going to walk you through all those questions so you know exactly what to do next time you're in this situation. My name is Bishoy Habib, and I've been a real estate attorney for over 12 years now. I've closed over 1,000 deals, and you don't get to that many closings without seeing your fair share of business disputes. Deals fall apart for many different reasons, but the general rule of thumb is that someone fails to hold up their end of the bargain in a contract and you suffer damages because of it, you can pursue them legally. Let's start with the classic buyer default. Maybe the buyer had trouble getting financing together, or maybe they're going through a divorce and they just don't want to close anymore. Whatever the reason, that leaves the seller in a bad spot. Many contracts are written so the seller cannot pursue damages beyond the earnest money deposit. That's what we call liquidated damages, which is when the parties predetermine an amount of damages in case one of them breaches. We use this when it's difficult to calculate actual damages. A lot of my sellers want to sue for time lost on market, or repairs they made for the buyer, or their own personal moving expenses. But oftentimes, these are not recoverable costs unless they're expressly stated in the contract. On the flip side, sellers can also get cold feet and breach the contract by failing to let the buyer access the property for inspections or refusing to close. In that case, the buyer can go one of two directions. If they don't care for the property, they could sue for their damages, like costs incurred in their due diligence and potentially lost profits. I had a client who was assigning a contract for a property, sue for their $100,000 assignment fee as damages, and win the case because the sellers failed to close. However, if the buyer really wants the property, they would sue for specific performance, which is where you get the court to literally force the other party to perform. It's a long and expensive process, but real estate is unique, and sometimes this is the only fair remedy. Where I see specific performance lawsuits the most is when the seller got worked in the negotiation and now they understand they're selling way below market value and they're trying to renegotiate for a higher price. So the buyer takes them to task. We can also sue third parties. For all my wholesalers out there, if you have a seller accept your offer and then that seller accepts a higher offer from a third party, here's what we do. Assuming the third party knows about your contract, which they should if you're doing it the right way and recording a memorandum of interest like I teach my clients to do, we would sue the third party for tortuous interference with a business relationship, which is when someone ruins a business deal between two parties on purpose. Now, there's a few very important things we need to address here. Mediation and arbitration clauses. Mediation is when a neutral party helps negotiate between the parties to reach an agreement. Arbitration is when a neutral third party hears evidence and makes decisions for the parties. Some contracts have mandatory mediation or arbitration clauses in them, meaning you cannot legally sue the other party until you go through mediation or arbitration. Sometimes mediation or arbitration are binding, sometimes they're non-binding. Make sure you know if your contract has one of these before you make any decisions. Otherwise, you could be wasting a ton of money for no reason. Demand letters. The first step in any dispute is to have an attorney send a demand letter to the defaulting party. A good demand letter serves several purposes. It lets the other side know you've retained an attorney and are serious about pursuing legal action. It lays out your position clearly and concisely, backed up by legal and factual arguments. It makes a clear demand of what you're seeking. It gives a deadline to respond, which puts pressure on the other side, and it opens up the door for discussion or reconciliation or negotiation, depending on what you're trying to do. You'd be surprised how often parties will come to the table and get things back on track even after reaching a boiling point. But it all starts with a well-drafted demand letter. And finally, recovery of legal fees. Now let's talk about this because this is by far the number one thing I get asked about when my clients are in a business dispute. The short answer is, if there's not an attorney's fee provision in your contract, you probably are not able to recover legal fees. It sounds harsh, but it's the reality. Florida does have a few exceptions where legal fees are given without being agreed upon in writing. So for example, Florida statute 501.2105, if the other party is using fraud or deceptive practices. Florida statute 57105 is there's legal fees going to one side, then the other side automatically gets the right to recover legal fees. And then bad faith claims as well, right? So we want to make sure the parties are acting in good faith, but assuming those things are in play, you have to have it in writing in the contract that you're entitled to recover attorney's fees. So the best approach to your situation really depends on the specifics and the facts. That's why I always tell my clients, get a real estate attorney involved from the start. We can make sure the contract is tight, that you've got the right protections in place, and that things like dispute resolution and attorney's fees provisions, contingencies, and all that stuff are in there and documented and buttoned up. A seasoned real estate attorney like myself can spot issues before they become real problems down the line. At the end of the day, real estate deals are complex and contract breaches are more common than a lot of people realize. But if you've got an experienced legal team in your corner, you're in a way better position to navigate those challenges and come out on top. I hope you found this video helpful. Please feel free to comment on any questions you have about this topic, or if you have any suggestions on other videos I should make. Thanks for watching, and don't forget to subscribe for more videos every week. I'll see you next time.